Good.
John, was this just open to people in Kensington, or are there people from other areas of the county?
This was, well, it's a Kensington ordinance,
Okay.
so
The invitation was only for the working group. We also have a few
and it's
names
really
here you might see for our interns this summer.
Oh, okay, that's
We have some high
it.
school
Or,
students. We have some high school students who are
for-
joining us.
Okay, great.
right. That's the other names you see are some high school students. That's right.
Okay,
Yes.
great.
Great. Do we want to do quick introductions? Everybody, you're in it, just who you are, Kensington resident or not. And why don't we just do that? And so we see everybody, and we'll start with Curtis and Tom, with County Council.
Hi, I'm Tom Geiger. I'm County Council.
Curtis Keller, Deputy County Council.
Go ahead, Wendy.
Hi, Wendy Lane, 30+ year resident of Kensington.
Linda.
Muting. There, can you hear me now? Yeah. Okay, Linda Lipscomb, 47-year resident of Kensington. Chief affiliation here in town is with the Kensington Improvement Club.
Candy.
Candy Capagrossi, 13-year resident and member of KPOA.
Robert.
Robert Haas, 30-year resident.
Catherine.
Catherine Deniergaard, 60+ year resident and member of the Kensington Democratic Club.
Okay. Gail.
Gail Feldman, 30-year resident of Kensington and director of the KPOA.
Hi, everyone. Robert Rogers.
Can you hear me?
Robert Rogers, staff to Supervisor Joya.
Hi, Diane Eggles, 30+ year resident of Kensington, same street as Wendy.
Calling out others here. Diane, can you hear me?
Yeah.
Great.
Oh yeah, I just introduced myself.
Pedro.
Yeah.
Got it. Thanks. Pedro.
Hi, my name is Pedro Ruiz, a lifelong Richmond resident, also an intern for Supervisor John Joya.
Skylar.
Hi, I'm Skylar Diaz. I'm a resident of El Sobrante, and I'm just a high school student and interning for John Joya.
Nikki.
Hi, my name is Nikki Barron. I'm a San Pablo resident, and I'm a high school student at Richmond High, intern for John Joya.
Isaias.
Hi, my name is Isaias. I am an intern for Supervisor John Joya, and I go to Richmond High.
Hillary.
Hi, I'm Hillary. I'm an 18-year resident from Kensington.
Great. Okay, we will start. Thank you, everybody. I know this is our working group on trying to strengthen our ordinance on tree obstructions. We did get a letter from KPOA that identified a few issues. We can go through those, cover anything else, and maybe we'll start with some easy stuff. We have about an hour, so we will get this done. And let me just do what I will do is do a share screen as well. But I will look I did send an email out which identified some of the issues and some preliminary thinking I had on those. So let me just go through those maybe real quickly. Hold on, let me pull it up. So maybe to start with some easy ones. The arbitration hearing notice, we normally send out notices of land use hearings and things like that to property owners within 300 feet. We have a requirement to do that here. KPOA was just wondering or questioning that. I actually feel pretty strongly about this, so just wanted to, put out there. So I just wanted to, we're trying to go through the points that were raised and just hear any thoughts about that. I mean, I always err on the side of transparency, and I just think other people may potentially be interested, and trees can impact more than one property. So within 300 feet is just that's typically what we do. So I just wanted to respond. That was issue was raised by KPOA. So just any discussion on that issue. Good. Okay. Everybody. Yes, Catherine?
Well, just that the views impacted would be presumably uphill, although the ordinance does call for considerations of beneficial use and other considerations which could impact people not uphill.
Yeah, so typically it'd be 300 feet from the subject property. So you would draw a circle around the property and it would just be people within 300 feet. I think it's sort of hard to go and try to determine, right, just like on a land use hearing, who's impacted. So the standard in the county ordinance has generally been draw a circle and it's 300 feet around. So it would capture the folks you mentioned, I think, may capture folks who won't be interested, but it just is an easy standard to apply.
Yeah, I think KPOA's reasoning was really that this is typically involving one or two property, maybe three property owners regarding a view. So bringing people in who may not be impacted didn't seem really necessary and could add to other issues being brought into, the discussion, even including people who just don't want to see trees cut at all, which if you read next door, you see people complaining about their neighbor's trees getting cut. So we were just thinking like keeping this simple because it's a very, as you know, the issues that have come up over the tree cutting or tree restoration, view restoration have been fairly emotional between neighbors, and trying to keep this as limited as possible.
Yeah, I think, the same issue, I think, Gail, applies to the land use hearings, because there are oftentimes we're going through a room addition appeal to the supervisors now under the view ordinance, and typically it's only a couple of property owners that may be impacted, yet we send notices to 300 feet, just sort of standard. And then, who knows, somebody may have evidence that, hey, this tree was or wasn't there, so it's another way that maybe people bring in evidence about whether a tree or a view existed when the property owner moved in. So it's pretty standard on that. And again, the same issues come up even with, of course, with the view ordinance for development.
Right.
Okay. So, yeah. Anyway, so we have that in. I think my sense is we sort of keep that in. The next issue was, and I actually agree with it, that the time frame to initiate restorative actions within 30 days may be too short. We may want it a bit longer. And I think there was a comment raised by one of the working group members, should we have a date of when it should be completed by? I think that's it. So, but right now, the time frame for initiating a restorative action was within 30 days of the arbitration hearing. I do think that's short, maybe something like 60 to 90 days. And then what do people also feel about maybe saying the work must be done within X number of months? I think that's an interesting thought. Hillary?
Hi, will there
Go ahead,
be
Hillary.
a time I don't want to ask questions yet because I don't want to interrupt the flow and there's a lot to learn. But will there be a place or a forum for me to ask questions based on the content that's been discussed?
Yeah, well, we've had hours and hours of meetings on all of these issues with this working group, and we sort of arrived to where we are now, and I'm trying to go through each point that's been raised individually and resolving them, then we can do that. And if you have other questions, you could raise them. So I was first trying to go through the points that were raised in the KPOA letter and try to resolve them. And then you can, if you have other questions, you feel free to ask them.
Thank you.
Sure.
So,
Yeah, on this issue, first, let's say how quickly, should we, there should be a requirement, I think, that somebody starts their restorative action within a certain time period. And 30 days is, I think, is too short, something in 60 to 90, and folks feel free to weigh in.
So when we say begin, does that mean just like getting the bids? I guess that's the thing that was a little unclear, is what initiating might be.
Yeah, I think, and that's a good point, we could actually say to start the physical work. Look, we don't want to dictate every step of the process, but I think maybe Tom and Curtis, the language here can be to start the physical restoration work, and that could, I know it'll take
How about
some
contracting?
time.
How about getting a contract? Because I just found that it was very difficult this past year, especially with all the fire inspections going on, to get my tree trimmer. I mentioned this to you, that it took a month for him just to get up to my house to give me the bid. And I don't know if this is true of all of them, but these are the ones that are, have reputations in the area for doing good work. So maybe that would be, that contract has to be agreed to within 30 days with a tree trimmer, because I don't think they're going to get over there to do the work that quickly.
Yeah, no, I think there, I was thinking something like 60 or 90 days to actually physically start the work, because we can't judge anyone can do a contract. I think that an objective standard would be physically start the work within 90 days or something.
I think 90 days would be okay. I think.
So how do others feel? Go ahead. Folks, raise your hand and I'll call on you, Catherine.
Yes, I agree. 90 days to start the work. It's very hard to get at certain times of the year to get arborists over to do an estimate even. So, yeah, the 90 days to start work seems reasonable.
Candy?
90 days is good.
If folks, yes, Wendy.
So I was the one that made the comment about an end date. So just to add a sentence or two about that, I think most of us have known people who, with good intention or otherwise, have started projects, and literally a year later, their addition is still half done or something. This is tree work. It's not building a whole new, building an ADU or putting on a second or third story. So I do think it might be helpful to give maybe a 12-month end time. You want to be fair and respectful, but you also want to make it clear that this work needs to be done. So just to throw that out there.
Yeah, a basic question maybe to county council. One of the things, as I think about, for us to put dates in here, how do we enforce these dates? I always look at enforcement. Let's say we did 9 months to complete the work, 90 days to start it. And I'm just picking numbers. What's a practical way to enforce these? There's nothing we can do other than, can we actually find somebody, given how we're developing this ordinance, rather than have somebody go back to court, which, we want to avoid, can we put an ability where we can find somebody for failing to meet those timeframes?
I think that would be the only place in this ordinance where we would actually kind of be going in and enforcing. And I think the whole idea is to get parties to come together. And so this is something that, unless there's a written decision, it's something that's mutually agreed to. So that would be kind of an anomaly for this ordinance to be going and enforcing, imposing fines for not finishing the work, because then it kind of changes the whole character of the ordinance.
What about
I'll just
the
add
idea?
the
What
one
about the
thing.
idea? Go ahead, Curtis. What about the idea of the start date? Starting the work.
I was just going to add that the language that's in there now with respect to enforcement of the binding arbitration decision is that it's enforceable under the Code of Civil Procedures 1280 sections, which is about enforcement of arbitration decisions. So that is a court process. It's not a county process, but that's how it's spelled out currently for enforcement of the arbitration decisions.
And how are those? So we could put a start and end date on that, right? Even if but it's not in the arbitration decision. The start and end date isn't in the arbitrator's decision. It could be. The arbitrator could actually put it in, but if it's not in the arbitrator's decision and it's in our ordinance, let's say, could it still be enforced through that code section in enforcing the arbitrator's decision?
Well, two things. I mean, there's language in there right now that, with those timeframes, it says if the decision specifies otherwise, those are the timeframes. Yeah. But I was considering that these timeframes, they're part of the arbitration decision, even if it's not spelled out in the decision, and they would be enforceable. I mean, we can.
Got it. Okay.
Maybe add another sentence about that. So everything would be incorporated into that enforcement mechanism that Curtis was talking about.
Got it. Okay. That seems to make some sense. Yeah. Go ahead, Linda.
Yeah, the only thing I'm thinking of is that applies in the case of someone electing to go to binding arbitration. If you have the situation where the person does not do that and you want, and I think I was catching from what you said, John, do you have the ability to create an enforcement mechanism by way of some penalty of some kind if they do not elect binding arbitration? I mean, it's still a problem.
Yeah. So what happens, Curtis and Tom, if it goes to our tree board?
Right.
Which is the MAC, I guess, right? We may make it the MAC, but a tree board.
So in the case of the fact finding, the advisory decision, I think is what's being referenced as opposed to the binding arbitration. Well, so that decision is, again, it's an advisory decision, and it isn't enforceable in the same way as a binding arbitration decision. What we included is that fact finding decision, that advisory decision, that if the parties then decide to go and try to litigate the matter, that there's a rebuttable presumption that the decision made by the fact-finding body would be.
Then it's really up to the court, whatever court order or court judgment is, that court judgment may say when to start and end. Okay. Right. So we wouldn't deal with that. The tree board's just going to make an advisory decision, which is not, it's in and of itself enforceable unless the parties go to court and then the judge, let's say, finds that the advisory decision was correct, and then that would be, the court would then order all of that information. Okay, so this just applies to the arbitration.
Okay.
Can we put it? I think putting a date. I like the idea of putting a date in here. I think that makes sense.
Yeah, we can do that. So you were thinking 90 days to start the physical actions, and then.
I think a year is too long. I don't know whether 9 months is reasonable. I was thinking 6 to 9 months. Any thoughts about that?
I mean, this is more of a common sense thought than a legal thought, but even 6 to 9 months sounds long.
Yeah. I'm just sort of watching a lot of these, how it comes before the board and other things. So we're saying 3 months or 90 days to actually start the work, and then maybe finish it within 6 months. Yes, Catherine?
I'll just comment that arborists collect all or, most of their money when they finish the job, and the arborist just goes in and does the job. They're not, they're not going to carry it out over 6 months. It's going to be carried out over at most 2 or 3 days, but probably only just 1 day, and then they get their money. So
just
FYI.
Yeah, And then if you look at the kind of the different restorative actions in the definitions, I mean, it's thinning, topping, removal, trimming. I mean, those are all, you know, fairly short term things.
Yeah.
I just think we don't want to get in the middle. Every situation's different. We're just trying to set maximum days here, right? No longer than 90 days to start the work. Look, this is not going to be perfect. And we're not going to get in the middle of deciding we're just trying to set, limits.
Yeah, I think there's just two considerations really. It's the time of year, because some trees can't get cut during certain times of year. And then the other is just getting the guys under contract and scheduling the work. So, I mean, I think 6 months is probably a reasonable amount. There's some time within that time frame, within 6 months, that they should be able to cut the tree due to the season. And then.
Right. Well, and if we said 90 days to start it, that means it's no more than 3 months to do the work.
Yeah, so starting, that's why I say, but when you say physically do the work, I don't think they would be physically necessary. They might just be coming and getting the contract done.
Well, but I want to make the standard. I want to make the standard when they physically start the work rather than the contract, Gail, because you can do the contract and then somebody may wait 2 months to start the work. I think the clear standard that's at least visible, it's all about results. 90 days. So that's, Tom, we're asking you to have that say, something like 90 days to actually start the physical restorative action, the physical work, and then 6 months to complete it.
Yeah, we can do that.
Okay.
I mean, that'll be left, obviously, no one's going to go take it to court over that issue because it'll be too costly. By the time they get it resolved, it'll already be 6 months.
Yeah.
Okay.
And we won't use the term initiated because, I mean, I think that initiated really kind of does imply going out and getting a contractor. So it'll be 90 days for physical actions and finish within 180 days, which is 6 months.
Okay. And then going back on this cost issue, this is just cost. Hold on here.
Can we maybe take up the other issue first, the one about the restoration, not the restoration, but that
the first issue,
the first one the one that
let me put up do a share, and why don't you raise what the issue was? What section? I will pull it up.
It's page 5.
And it's section initial reconciliation, correct?
Yeah, it's under procedure, I believe. Let me just look at it here.
Yeah, it is. Let me do it. I'm doing a share screen. Let's see here. Okay, can everybody see this?
Yes.
Okay, good. All right. So this is the language. What was the KPOA comment on this, Gail?
Oh, so the question was, this addressed where there was a view obstruction when the property owner purchased the property or acquired the property, and they want to have a view created, basically. And so that seemed a little bit outside of the intent of the ordinance, and we were wondering whether or not
the red language. Okay.
Yeah, the red language. And so the question was whether or not we should include it at all. But also, like, did that mean then you could go through either the tree arbitration board or the fact-finding process?
All right, good question. So let me go back. What the ordinance does, and I'm going to try to, if you can see me scroll. Can you see what's on standards? Can you see this? See Article 816. So the heart of the ordinance here is a process to enforce a right, and the right here is a claimant has the right to seek restoration of views or sunlight that existed on the claimant's property when the claimant acquired the property, where the views or sunlight have been unreasonably obstructed by the growth of trees. So a claimant has no right to a view greater than that which existed when the claimant acquired the property, and then the claimant shall provide evidence. So this is the key provision, right? And which is sort of what exists today under the ordinance. You have only to the view that existed when you acquired the property, right?
Right.
So this issue under initial, and so under initial reconciliation, right? The language is if a claimant believes in good faith that the growth, maintenance, or location of the trees diminishes the property, the claimant shall notify. And then it does say when a claimant notifies a tree owner of those concerns, the claimant should also attempt to discuss those concerns in person with the tree owner, if possible, to enable the claimant and the tree owner to attempt to reach a mutually agreeable solution to the alleged view obstruction, including a mutual agreement on cost related to any restorative actions or replacement plantings in accordance with the provisions of this chapter. So basically, that's the key is that we're trying to get people to come to an agreement voluntarily and reach agreement on the cost, right? And so the question being raised, if the claimant is seeking to restore a view that did not exist when the claimant acquired the property, and if the tree owner agrees to restorative actions not required by this law, the claimant should expect to pay all costs of the restorative actions unless the parties agree on a different allocation. So I guess I'll have to think back, what this was designed to say is if two parties, if someone says, hey, I know I didn't have a view, but I would like to get a view, can we work this out? Can we work it out and come to an agreement? So that's what this is seeking to address.
Right. So the question is, though, if they can't do that, would they have the right to take this to the tree arbitration board, which I think,
Good question. So Tom and Curtis, it seems right? I mean, if the whole ordinance is designed to protect the view that existed on the date you acquired the property, and that's what goes through mediation, arbitration, the tree board, it would seem that if on this last one, maybe I'm not sure it was intended that this all then goes to arbitration. This is just meant in a good neighbor way. And we could put in some language that says, we're trying to encourage people to work together, but we could clarify that this does not, this issue, if it's a new view, doesn't go to arbitration.
Yeah, and I think that was the intent, because this is just in the initial reconciliation section, so we can add a sentence to clarify that.
Yeah, and also not the tree finding, because I just think it'll end up clogging up. I mean, there'll be more interest in creating new views, and that would create a lot of work for the arbitration board, which I don't think we intended.
So for the initial, so this only, I think that was the intention, is that this then, and we can put it here, that or in the appropriate place, Tom and Curtis, that new views, and the ability to restore a view that did not exist is an initial reconciliation step, but is not go to the tree board, or is not litigated, or doesn't go to arbitration.
Yeah, I think, we'll put it in this section. I think that's the best place for that.
Yeah, just for context, my notes reflect that there was interest by this group to include something about this new view, and it's really relating to costs and this initial reconciliation phase, to make the point that if you want a new view, you should pay for it. But so yes, it was intended just to reflect.
And the bottom line is two parties have to agree to this. We're not forcing anybody to reach an agreement on this. Catherine?
I just wanted to support this idea of being open to, including people having a process to, as stated here, not more than is stated here, to talk about. And when we talk about new views, we do have to remember that previously there were kind of unlimited views, because the hillsides were just grasslands with very few trees, 100 years ago. And, it's kind of amazing how much, even in my lifetime, all these trees have grown up. But at any rate, I really like this additional clause, and I don't think it should be that this, you can't really, I could see saying, excuse me, I'm saying, that this isn't a part of the arbitration process, but I don't think we should say more than that, because it's not our business. We can't say you can't litigate this. I don't think we should mention litigation.
Yeah. Yes.
Well, actually, you can say that, as far as the county's policy is not to give a right to create a new view. That's
Yeah.
I think we're trying to be very careful about not.
I mean, we can't stop.
That's clear.
I think we can't stop people from filing a lawsuit, but the county ordinance is clear that the only right that is potentially enforceable is the right to the view that existed on the date you acquired the property. So someone may still litigate and say, I had this view or whatever, but at least our standard is clear in the ordinance that it's only the view, so yeah.
John?
Yeah.
One problem I would say is I would change the word restore probably to establish a view.
Oh, I see.
If you're in that area.
To create.
Right.
Yeah.
It's to create a view. Yeah, that may be better than restore, Tom.
Yeah, because restoration is, as Catherine points out, I have pictures from 1952 where, as she said, it was simply grassland on the hillside from when my house was created. So if you're talking about restoring it back to that, I would think you would talk about establishing a view rather than restoring the view. That small change.
Mm-hmm. So
also, it makes it more land use than it does just strictly tree obstruction of view.
So Tom and Curtis, is it clear to you?
Yeah, that's fine.
Okay.
I mean, yeah.
We're going to be clear here that this is only an initial reconciliation stage. If it's a new view, it doesn't go through the other stages, and it's to create.
Yeah.
By the way, let me just look at the red lines here from the last. This is B. This is the section under voluntary mediation, and it said what we changed. The mediator will not have the power to issue binding orders for restorative action, but must strive to enable the parties to resolve their dispute at this stage by reaching a mutually agreeable solution to the alleged view obstruction, including a mutual agreement on cost related to restorative actions or replacement plantings and so forth. So that's just the mediation section. That was a change from the last version. Now this one on the arbitration, the filing, this was new. So the filing fee, this is the filing fee for arbitration. The filing fee for a view claim will be established by the board. And what we're saying here, hey, the parties can agree on whatever allocation they want, but if they can't reach an agreement, then it's 50-50. I feel, so it does allow folks to reach an agreement, and there's a default if they can't reach an agreement, which is 50-50, because this is an arbitration that they've agreed to do. We're not talking, this is not about the restorative action cost. So this is more about the filing fee. Any questions on that?
Yes. A couple of comments. One is going back to what we were just talking about. I just want to make sure, to be the devil's advocate, does this cover if one party says you're asking for a new view and the original party, the claimant, says this is part of the original view, I can't prove it, but I'm telling you, your tree is new, is a new impediment to my view. So I just want to, are we anticipating that there will be disagreements that are not provable? And then the second question was just curious why that 50-50 should apply only to the filing, as you know, the arbitration fee, as opposed to the actual remediation. Just curious. Thanks.
So, I mean, ultimately, things aren't going to go to arbitration unless both parties agree. So, you know, you could realistically, the fact that both parties are agreeing means they're trying to resolve it. If the owner of the house with the tree feels that there was no view that existed, and they feel like they don't even, that there's not even a claim, they're not going to agree to go to arbitration. So, I mean, I think that's the dynamic, is this is a voluntary process. So when it's going before the arbitrator, at least the owner with the tree is agreeing to try to resolve the issue. Right. So I think that's sort of the answer to that. And in terms of the cost, yeah, remind me, Curtis, and I think the
allocation of cost in sub G. Right there.
Yeah, the cost issues, are those come up in the arbitrator's dissect?
Yeah, if you scroll down, sub G in that section talks about that the arbitration decision will include an allocation of costs.
Yeah, so we're not getting into that. That is what the arbitrator will decide based on the evidence presented. So what we're just saying is for the filing fee, which is before the decision comes out, right? We're agreeing people can decide to figure it out. If they don't, it's 50-50. And ultimately, again, 50%, I want you to pay 100%. I'm not going to go to arbitration. So remember, all of this subject to two parties reaching agreement to go to arbitration. So I'm not sure it's a big issue one way or the other. We're basically leaving it to the parties. Gail, and then Catherine.
Yeah, so I'll just speak to, you know, KPOA raised this issue as well. I mean, from the experience that I've had with the complaints that I've gotten when people call about, you know, or write to us about their situation, I don't believe that this will necessarily help people who have a neighbor who's being uncooperative, where you may, you know, anytime you ask somebody who doesn't really want to have their tree cut to pay even a portion, you're just adding more reasons for that person not to cooperate. So, and I thought it was also a bit odd to have that one place where the county dictates the share of cost.
But we're not dictating. We're saying you decide, and if you can't reach agreement, then it's 50%. And remember, somebody can back out and say, I'm not going to go to arbitration.
Right. But we were, you know, I guess I just feel like we're intending this to try to resolve these issues, as opposed to people, you know, saying they have to end up going to civil litigation. But, you know, it's a very small fraction of the cost. So it's not really the biggest portion. It's just, I just felt like it was more, or KPOA felt like it was more consistent, just not to even have the county dictate the share of cost in the ordinance.
Well, and I think the reason it's there is because this is where the county is involved the most.
True.
Yeah. This
anyway,
and they've already agreed to go to the arbitration board, and I think that, you know, we wouldn't want it to fall apart just because they can't quite agree on who pays the filing fee.
I mean,
what are we talking? A few $100?
Right. No, I understand that. Yeah.
Right.
I'm just saying, I don't want to create any barriers for people who get this far in their agreement to try to resolve their issue. That was the main concern, but I'm not, you know, this is just our concern.
Sure. Catherine, you're muted.
Regarding the fees decided by the Board of Supervisors, I'd just like to make note that some 25% of Kensington is low income, presumably low-income seniors. And I know the Department of Conservation and Development, they're pretty substantial fees for doing things. It's sort of pay as you go to some extent. And I hope in this case, this process can be fairly accessible to low-income people.
Well, let me just say, there's a lot of more low-income communities than Kensington, like North Richmond. And I don't know, we have our fee standards. We try to keep fees reasonable. Right now, I don't think we have I don't think we have any fees in place, do we?
No, we'll have to establish that when or DCD will have to establish that and take that to the board.
Yeah, I think we try to keep fees as reasonable as possible, and so yeah.
Yeah, I mean, it's only to cover our costs. We can't make a profit.
Right. Yeah, it's not a fee to make money, it's a fee to cover
No,
the cost, right?
no, I do understand that, but even so, cover costs can be a barrier to low-income people, of which there is a substantial number in Kensington, despite the high average income.
Well, you have one of the highest average median incomes in the county. So let me just say, if you go to the Board of Supervisors and make that argument, the folks who represent North Richmond and Bay Point and Rodeo are going to say, well, our incomes are a lot lower, and they're right, but we don't have anything in place generally right now on this, right? We don't have, I mean, I know there are seniors on fixed income. So again, we're probably talking and we're talking a fee of probably a few $100s, right? Right. And anybody who owns property in Kensington, their house is probably worth over $1 million. Right. Okay. No, I hear you. I think we try to keep it reasonable. Right. Anything, I think those were
John, you're cutting out.
Things removed. If I go, I know it's my internet, it says. Is that better?
A little bit.
Hey,
Sorry.
John, can we go back to the time frame for initiating actions just for a second?
Sure.
Yeah, so we have the 90 days to start and finish within 6 months. One thing that I noticed, though, there may be a case where you would have to go get a permit from DCD if it's a protected tree.
Yeah.
So that might affect the timeline. So we could carve out an exception for that too.
Okay.
That'd be good. Thank you.
And then can you hear me okay? Is my internet better?
Yeah.
We took out this provision here, the cost of arbitration shall be apportioned between the claimant. That's all going to be in the decision.
Mm-hmm.
So that's why that's out. Okay, so I think those were the issues that we had that came up. I'll move back to page 1. Are there any other questions or comments? We have about 15 minutes left. I think we resolved the issues that were identified by KPOA and then a few others. Are there others that people have?
I don't have questions about the rest of the ordinance, but I do have questions about the process and if we can get to how we can move this forward, because it's been sitting around for a couple of years now. Yeah.
I was going to raise that next. I was going to just to see first, are there any other questions? Yes, Hillary?
You muted.
Hi, yeah. Hi, okay, I'm unmuted now. Thank you. I actually have a series of questions, and I'm not sure that this is, they're very much me oriented. So think that the thing for me is to know who a live person I can have a call with to get my questions answered. And yes, first, that's my first question, because I
Yeah,
haven't read the ordinance and I'm
have you
curious
been on-
about the
were you
new
on the-
mediation step.
Is this your first working group meeting?
It is. I'm standing in for a neighbor of mine,
Who,
Mary Olivella.
Yeah, I
Mary
know.
Olivella.
Yeah, I mean, this is, I mean, I know we've had consistent, that's why we sort of established a working group where
Mhm.
everybody's been engaged in these, and we had discussions, but you can ask some questions. We sort of reached consensus about where we are today with
Mhm.
the views. Did you want to ask some questions quickly right now that we can
No,
try to answer?
well, one, just so I might take Mary's place in the working group if that's okay, because she has some
Sure, although this is
conflicts.
probably our last working group meeting.
Oh,
We'll
okay.
talk about
Well, then
process. Yeah.
who should I talk to? A person.
You can call my office, call Robert, and between Robert and I, we can see what your question is and respond to it. Yeah. Why don't
Okay.
you do that?
Or yeah, I could also write my questions.
Yeah, you can email them
And-
to me. That's fine.
Okay.
That actually
Okay.
would be good. Email them.
And to you directly, or to you and Robert?
Yeah. You can be to me and copy Robert.
Okay. Thanks. I won't take up
Yeah.
any more time for you. I know you've been working hard, and I appreciate that.
No, email any questions and we can try to answer those. Candy?
Yeah. I'm just wondering, I've watched trees be thinned. I've watched them be overwatered and be fully grown again in less than a year. Do we have any kind of longevity, or would people have to do this every year?
Well, I mean, the idea is hopefully that people are trimming their trees on a regular basis, right? If that prevents them from blocking somebody's view. And hopefully this is why ultimately this comes down to neighborliness, right? And this ordinance is really only designed to resolve issues where maybe the normal discussions between neighbors isn't working. And hopefully this is just, let's hope this is the tip of the iceberg and all the other things below the surface are being resolved on some basis without going through the ordinance. I don't know. I mean, there haven't been a lot of issues. Well, current ordinance really forces people to go to court, right? Doesn't have a process like this. So, yeah, I think ultimately it does set up a process where every time somebody has a blockage, they pursue the ordinance. So I guess let me ask, let's say there's an arbitration decision to do something. I'm wondering if and this is to our legal folks, if the arbitrator's decision becomes then an ongoing, let's say an ongoing sort of order. So let's say the arbitrator says, this is the view, this is what it should be cut to or trimmed. And let's say 2 years later, it's blocking the view again. Can they rely on that previous arbitration decision for enforcement, or they have to go through another one?
Well, the arbitration decision as a binding decision is recorded against the property. And as you said, the decision will do a couple of things. It should define the view claim and what the extent of the view is. And it'll be coupled with restorative actions in order to restore that view, at least to the extent that the decision finds that view exists and that right should be restored. So that portion of the decision is going to exist as it's recorded against the property. So while the restorative actions defined in the arbitration's decision may need to be repeated, you'd already have something recorded against the property as to what the tree arbitration board found was the appropriate view. You might need to go back in and enforce that decision again through those arbitration enforcement measures that we discussed, but you'd already have a decision by the board as to the extent of the view.
Got it. So that may answer that question, Candy. Yeah, that. Yeah.
I wish we could have something that would say and should be maintained or something, you know, something like that. And meaning they may not, but at least
I think that's implied, right, in the decision that the arbitrator's view decision is that this is the view you need to make, and you need to keep your trees trimmed to that level. And then you've established a process, and hopefully the property owner maintains their trees. And if they don't, then the other property owner has to go in and just get enforcement. Sounds like they don't have to go through the process again. They just enforce the order.
John?
Yeah, I first have Catherine had her hand up and then Linda.
Okay. I just wanted to support Candace's idea. I think I would like a little bit of language about, and something like it is expected that the view would be maintained or the tree would be trimmed periodically to agree to the arbitration. Something like that would be great, just as a clarification.
Tom and Curtis, what do you think about that? Or is it implied in the decision? If we put it in, what's your thought about how to do that?
I mean, it's kind of implied. I think that, you know, some of it too will depend on kind of, you know, the type of tree and how fast it grows, that kind of thing. So I think there's some, you know, discretion in terms of what the final decision is. You know, because it really is hard to say kind of what the restorative action is going to necessarily be. I mean, it could be like a really big restorative action where it might take a while to get, you know, go back to closer to where it was, but yeah. So, I mean, we can add something that says, you know, something like regular maintenance may be part of the decision. But I do think it really does depend on kind of the
to maintain yeah, or in a way, you're saying we're maintaining to continue to comply. You know, we're asking folks to continue to comply with the arbitration order decision, right?
Right.
And whatever that compliance means.
Because the decision should decide the extent of the view that they have a
right.
So that's the piece
that's why it's rather than say we could say that they'll continue to comply with the arbitration order, right?
Yeah, because the restorative action really is a one-time issue because it's going to be the restorative action necessary to restore the view, and that restorative action may not be necessary in the future, right?
But let's say the tree grows 5 years later, right? Then they need another restorative action if they're not trimming it, but they have the order, so we want them to continue to comply with the order, right? Whatever that means, we don't know what's going to be in the order.
Yeah, and maybe it's a little less of complying with the order. It's more kind of like, you know, once the view is established, you know, that view is expected it'll be maintained, something like that.
Well, one thing I can just see as an issue, but I don't think it's a problem to put that in there, but does this go with the property owner then, or is it with the property? So,
yeah,
you know, then you're creating, you know, a requirement for the future property owner.
Exactly. You may be affecting the value of the property. You know, another hat I wear or wore for a while is realtor. And I can tell you any encumbrance on the property, not only is a matter for disclosure if there's a transfer of title in any way, but it becomes then an ongoing monetary obligation. Suppose you have a tree that you window. Windowing a tree is quite expensive. And if it's an ongoing cost to continue to window that tree and at what level, then
That's
it's,
gonna be, right, that's gonna be up to the
isn't,
arbitrator,
yeah, it's a
not
real
us.
thorny issue.
But so do these decisions run with the land?
Yeah, they will if they're recorded
guess-
at what, actually, they're going to be disclosed, because if they're recorded, the disclosures upon I'm assuming the decision of the board is going to be recorded as an encumbrance. And if
I
that's
could
the
ask legal
case,
about that,
Well,
yes.
so I think that, you know, the decision is recorded, but since it's not a permit, it doesn't run with the land.
Okay.
Yeah, we did talk about a bit about this. That's right. And it's an arbitration decision between two parties. It's recorded against the property for disclosure purposes.
Yeah.
So that if
Ah.
it was a new owner, they would likely need to obtain a new agreement with that new owner. But you would have something recorded and put people on notice that. So, for example, if you had to go up and prove up your new view claim against a new property owner, you will be able to show that you've already done that through a prior.
That's right. That's right. And I can tell you, if I were selling a property that had such a recorded item against it, I would certainly disclose it and ask them to seek counsel on enforceability.
But remember, what happens is your right is a view that existed when you bought the property. So, and so what your right your view right, if it is was the day property.
Yeah.
So the arbitration applied to that property owner. The new property owner, it would be something different. Right.
Yeah, I mean, I'm fine if it's between parties and we're not creating obligation. I mean, I think this is something that we'll have to talk to the real estate industry that represent the Kensington properties. And I mean, I advise my neighbor next door to take photos of the tree that blocks our view and put it in their disclosures when the new property buys it. So they have the photos of what the view is right now when they buy that property, because I didn't have that. So it's going to be harder for me to prove. But yeah, you know, that's the way it's going to have to work. But anyway, I think you could put some language just that it implies that the view will be maintained by the parties.
Right.
Yeah, and it's the individual agreements. Granted, the individual agreements go from person to person, but ordinarily we don't have to tell people what the law is in when we do a transaction. We have to tell them what affects the property. But if parties have an agreement to come upon one another's land, you want to disclose that, because for one thing, you know, you're going to have this ongoing monetary obligation. And what are the rights of entry? I can just see a whole slew of things emanating from this, from the ongoing right.
All right.
I just bring it up. I mean, we may not be able to resolve that.
Right.
You know?
So as to the process, I do think we would normally take this to the MAC. We'll have the changes made. I don't think we need another working groups. I want to thank everybody for their work. What we'll just do is schedule this as quickly as possible. Once we get the changes from County Council to a MAC meeting, which may be August. I don't know if the MAC meets in August. I don't, they meet the end of the month, right, Robert?
Yes, the last Wednesday of each month. We meet tonight.
Could be the end of July, possibly. So maybe we'll see what their agenda is, where it's just you know, we've used the MAC to even though we can talk about the work group, everything that's been done, and take it to the MAC. They could, you know, provide any additional comment of, I think we're pretty good, and make any recommendations, and then we would prepare this to go to the planning first, or it's an ordinance change, so maybe it doesn't need to go to the Planning Commission.
Well, it's in Title 8, and so I think DCD's expectation is that it would go to the Planning Commission. And
yeah, it's a zoning.
Yeah, I mean, because technically it's a countywide ordinance, even though right now the only combining district is Kensington.
Yes. Well, it only applies in Kensington because just like the other ordinance.
Right, because right
on
now
Portland.
Kensington is the only one with the TOV designation.
Yes.
Yeah,
The
so
end of
planning
the
commission and then the board.
commission. Yeah, we'll have to work with TCD to get this to a planning commission meeting, maybe in August or September, right?
Yeah.
Do you think it can move that fast?
I don't know. We'll see. We'll work on, I think we can bring it to the MAC in July. Just to have it on and there, and then work the best August or September. And then
That'd be
from there
great.
to the Board of Supervisors. Okay.
Okay.
Thank you very much,
Thank you,
John Joya
everybody.
and
Thank
Robert
you.
Rogers.
We all
Thank you. You're
Thank you.
fantastic. Thank you,
Tom and
committee.
Curtis.
Thank you.
Also,
Thank you.
Thanks all the
right.
staff.
Thanks,
for working on
everyone.
this.
Yes,
All right.
thanks, staff.
Thank you, staff.
Fantastic.
All right, thank you.
Yay.
Do